is going to be our speaker, and he's a partner now with the law firm of Hansen, Lulick and Kral. Is that?
Lulick.
Lulick and Kral. Okay, thank you.
He's Croatian. No one ever gets it right.
He's been involved with fire litigation since 1988. He's a graduate, 1985 graduate of Marquette University. He predominantly works in cases throughout Minnesota and Wisconsin, although it has been a 5-state area. They're involved litigating first-party insurance claims, liability defense, and property and casualty subrogation. Kevin was recently invited to work with the Minnesota Attorney General's Arson Task Force and provide input into proposed legislation affecting the property insurance industry. So, without any further ado, I'm going to turn it over to Kevin and let him have the floor for a while.
Thanks, Scott. No one told me this was going to be on camera, so
Good release.
I'll try and work through it. Well, I do appreciate the opportunity, not just for myself, but on behalf of our entire firm, to be here tonight and to be able to kind of give a little bit of a overview on some areas that might be of interest to you in the fire litigation area. As indicated, our firm, Hansen, Lulick & Kral, does a lot of fire litigation work. I would guess 90-some% of our work is related in some way, shape, or form to fires, fire damage, property losses, that kind of thing. I've been doing it for about 8 years, and again, I think we've carved out a niche, and hopefully the more we do it, the better we get at it. But you guys can decide that after hearing from me tonight. I always do in cases like this where there's a happy hour. I try to encourage that happy hour gets stretched out as long as possible, because then whatever I say comes across crystal clear. So, hopefully that'll be the case. Fire litigation. Let's just start out there. In general, that topic encompasses a broad area. You've got first-party insurance claims, which again we deal with quite often, and those are where you have an insured, whether it be a homeowner or a business owner, who has a fire, and they make a claim to their insurance company, and the insurance company, for one reason or another, says we don't owe for that loss. Litigation results. We step in, and quite often we defend the insurance companies in cases like that. Oftentimes they involve arson by the insured, fraud, misrepresentations, that type of thing. That's one area of fire litigation. Second is what we call the third-party insurance claims. Those being typical losses, fire losses, or they could be any other types, water losses, things like that, property, where the insurance companies, by and large, step in, pay their insured for the loss, and then they want their money back. So they want to subrogate, and again, we step in and try to assist there. Those are the types of cases where I'm going to be involved with mostly tonight, is the third-party type actions where you have looking for the faulty party, if you will. Why did the fire happen? Why did the water loss occur? And is there some negligence or lack of reasonable care that requires litigation? In those types of cases, there's various theories of recovery. The architect, the contractor may be negligent. You may have a products liability case, a coffee maker, or some compliance allegedly started a fire. Breach of contract or warranty issues. I think all of you are very familiar with contractual obligations in your business, and those are quite often one of the issues that you have to deal with. Tonight I picked several topics that I thought might be appropriate for some or all of you, and those are essentially three areas. I wanted to touch on one particular area of law that has kind of developed recently to a large extent because of our firm's involvement, dealing with the Uniform Fire Code and its applicability to existing buildings. So I'll touch on that first. The second area I wanted to touch base on was use of demonstrations or tests or experiments in trial. What you need to be aware of at the very earliest stages of preparing these types of demonstrations so that you don't waste a lot of time and money preparing them and then find out later that a judge is going to say, well, they don't pass muster and the jury's not going to see it. And then third, I wanted to address some of the more general areas in contractor liability. More focused on the architect's liability than the contractor's, but I will address a little bit of that as well. And if anywhere along the line, please, if anyone has a question or doesn't understand something or I'm way off base, please just raise your hand and I'd be glad to answer any questions that I can. Let's start with the Uniform Fire Code. Now, the history of the Uniform Fire Code in Minnesota is that it was adopted here in 1975. Well, when the code was adopted, you've got a lot of buildings out there that have already been in existence. To this day, there's still quite a few buildings out there, obviously, that were built and construction was completed before 1975. So how do you deal with those types of buildings when it comes to the Uniform Fire Code? Well, what the code did in Minnesota's version that they adopted, included it, is it contained a provision which some of you, probably most of you, have heard of as what people call the grandfather clause. Unfortunately, the grandfather clause isn't what people think it is. The common perception is that, well, and I've heard this from a number of people, origin and cause investigators, public sector investigators, state fire marshals. Well, the building was built prior to 1975, code doesn't apply, they're grandfathered in. That's not the case. And only recently has that been recognized by the Minnesota courts. The actual language of the grandfather clause is interesting, and it's something that actually my partner Joe Lulick was the first to really address in the state of Minnesota. And let me just read briefly from that. It's section 1.103B of the main body of the fire code, and it's entitled Existing Conditions. And this is the provision that deals with buildings in existence at the time the code was adopted. It says the provisions of this code shall apply to existing conditions as well as to conditions arising after the adoption thereof, except that conditions legally in existence at the adoption of this code and not in strict compliance therewith shall be permitted to continue only if, that's the key words, only if, in the opinion of the fire chief, they do not constitute a distinct hazard to life or property. So, I mean, and again, for the last 8 years, I've heard a lot of people say, this building is here, you can't allege fire code violations because it was built prior to 1975. But we looked at it, and that's not what that provision says. It says it will be exempted, this particular building, with the hypothetical building, will be exempted if and only if the fire chief, a fire official, state fire marshal, whoever is the one responsible for code compliance, determines that these conditions of the building that don't conform to the code do not constitute a distinct hazard to life or property. A lot of times this issue comes up with sprinkler systems. I'm going to touch on a case too that we were involved in that dealt with high school fire, and this high school wasn't sprinkled. Well, the code requires a lot of these buildings be sprinkled, even though they were built before the code was adopted, if no fire official has determined that there's no distinct hazard to life or property. The first case that dealt with that is a case called Aldermans versus Shanks, and what that case was a civil lawsuit, and the facts of that case are that there was a fire, I believe it was either late 80s or early 90s, there was a fire up at Brainerd in a plumbing shop, and the fire started in that building and spread to adjacent buildings. It was in the downtown area, so there was one building right next to the other. And this was a pretty large loss. insurance companies came in, they paid the loss, and then they subrogated. And what they determined was the fire started in the plumbing shop, and they sued the plumber. Well, our firm handled the subrogation case, and through investigation found out that there were a number of code violations, fire code violations. Lack of a door in the boiler room, lack of a sprinkler system, just to name a few. Well, in doing the investigation, well, first of all, when the lawsuit was brought, we alleged, in addition to other theories of recovery, that the plumber was negligent as a matter of law because he didn't comply, his building didn't comply with the Uniform Fire Code. Well, in doing some investigation, we found out that a fire official had inspected this building and had cited the owner for some of the non-conforming conditions, some of the conditions that didn't comply with the code, but didn't cite others. And so we proceeded to trial knowing that. The trial court said, I'm not going to give the jury an instruction on negligence as a matter of law. And for those of you who aren't real familiar with the negligence idea is, if there's a statute, be it a code or some other statute that's enacted for purposes of safety, life, property, and it sets out specific requirements that you have to comply with, and you don't comply with those, the court can instruct a jury that party is negligent as a matter of law. Well, the trial court refused to give that instruction in this case because there was a fire official out there, and he had cited some conditions but not others. It was somewhat confusing, and as what happens in a lot of these big cases, unfortunately, is it went up on appeal after the jury had found for the defendant, for the plumber. On appeal, we argued that existing condition clause and said, look, the fire official did not specifically make a finding that the non-conforming conditions did not constitute a distinct hazard to life or property. The Court of Appeals agreed with us. They said, that's right. The existing conditions provision, the grandfather clause, does not automatically exempt existing buildings. You have to have this fire official make a finding. So we won at the appellate level, and then the defendants, or the attorneys for the defendants, appealed that to the Minnesota Supreme Court. Well, the Minnesota Supreme Court came out with a decision in 1995, just last year, early last year, that said it agreed with the Court of Appeals that the grandfather clause does indeed require an affirmative act by the fire official. But it focused on this particular fire official's conduct and said, well, okay, he went into this building, he cited certain conditions, he cited the building owner for them, but he left some of these other ones uncited. We're gonna determine that he impliedly found no distinct hazard for those conditions that he didn't cite. Otherwise, he would have cited them. So what the court said is essentially that the silence of the fire official in not citing those certain non-conforming conditions was enough to say, well, there wasn't a violation of the code. And it just so happened that in the alderman's case, the non-conforming conditions that the fire official did not cite were the ones that the expert said resulted in the fire. So what we found out is, as of early 1995, we've got a real issue with existing buildings. Well, another case came our way, and this is the high school fire I was referring to earlier. There's a little town called New Fulton, up about 20 miles northwest of Thief River Falls, and they had a high school up there that burned, I would say, half the school was gutted. And that was a 1991 fire that didn't get into suit until about 94. And it was insured by Cigna. They went in, hired their cause and origin investigator and an electrical engineer, and they determined that the fire was caused by a coffee maker in the teacher's lounge. In that case, we were on the defense side. We we came in and defended Bonomatic Corporation for Aetna. Aetna was their insurer. And again, we did some investigation. We find out this school was built in 1970. Okay, so we went to the existing buildings section of the code, looked at the fact that the school did not have any sprinkler system in it at all, and then went to the code and said, should it have? And we had a fire protection engineering firm out of Chicago consult for us, and they said, yes, absolutely. This should have had approved automatic sprinkler system in it, and as a result, they violated the code. So, a little bit different twist. We're on the defense side, but we're using the fire code violations as a defensive tactic, saying, plaintiff, school district, you should have had this school sprinkler, particularly a school where you've got kids in it all day long, athletic events at night, that kind of thing. Public is in and out of this place. Well, the experts didn't stop there. Not only did they say it should have had a sprinkler system, but they said if an approved sprinkler system was in this building, the damage would have been significantly limited. That the fire would have been contained to the area of origin, to the room of origin, and you're talking, and they were estimating damage of about $10,000. Instead, this school had damages of $6.6 million. So, you know, again, we're defending the coffee maker manufacturer and doing all the necessary things to say, no, this coffee maker did not start the fire, you're way off base. But we had this side issue, so to speak, of plaintiff, you were negligent. You should have had this building inspected. You should have had it in a condition so that it met the fire code. And don't use the grandfather clause to get out of it because it doesn't work. Well, we knew about the Alderman's decision at that point, and so we went to trial in that case, in this Bonomatic Corporation case, and we got back to this grandfather clause. Well, the trial judge in the Bonomatic case said, well, let's see, the Alderman's court said that because of the silence of the fire official, you can imply that there was no distinct safety hazard. And so there was no violation of the code. Well, the school district was never inspected, the school itself, the high school, was never inspected from the date of completion in 1970 until the time of the fire in 1981. 21 years with not a single person walking through that building for fire code compliance. We asked the local fire chief. He says, no, that's not my job, that's the state's job. And it was it's a small town, it's a volunteer fire department. I don't think, quite honestly, and this isn't a criticism of that department, but I don't think they would have known whether it violated the code or not. So we talked to the state fire marshal. And in fact, John Nischia was involved in that case. We had quite a few discussions with John. And he is now doing a lot of that inspection of high schools and things like that. But that wasn't organized until after this fire. So, in fact, John went up and looked at this high school shortly after the fire and said, boy, he was one of them that said, there should have been, if there had been a sprinkler system in this building, damage would be minimal. So anyway, so the trial court, the judge up in Fulton is saying, okay, there was no inspection by anybody. So I'm going to take Alderman's and take it one step further and say, because there was no inspection, you can't find a fire code violation. We were just tearing, we were pulling our hair out, going, that's not what Alderman says. Nonetheless, that's the way he held. On appeal, I hate to admit it, but we lost that case too. The jury returned a verdict of $6.7 million. But it is on appeal. In fact, we went to appeal on a number of issues, evidentiary and whatnot.
Appeal it again.
But one of the main issues we had was the court should have instructed on the fire code. And what the trial judge did was he said, no, we're not going to talk about the fire code, and you're going to be sanctioned if you do. And you're not going to talk, even utter the word sprinkler system. And we're like, yes, Your Honor, yes, Your Honor. Mumble, mumble, mumble under our breath. That's the way it went. So on appeal, again, we argued, look, the situation is much different than Alderman's. There's been no inspection. You can't say, it's not the situation where a fire official went in, laid his eyes on something and said, I don't consider that a distinct hazard, I'm not going to cite you for it. There was nobody ever in the building. So unfortunately, that case has not been decided yet. We expect a decision any day. And we are quite confident that the court is going to agree with us that we've got to have some inspections, something in which to imply that there's no distinct hazard in order to get, by this fire code violation argument. So in any event, I know I've gone into a lot of detail on that issue, but the conclusions to reach in that particular topic are number one, pre-existing buildings are not automatically exempted from the fire code under the grandfather clause. And that needs to be kept in mind by everyone who deals in that area. Also, you need to look very specifically at the actions or inactions of fire officials because it has a serious bearing upon whether there is any causes of action or liability for code violations. And it's also, very important to know that violations of the fire code can be used both offensively and defensively, like we did in each of those two cases. Now, the next topic I want to address.
You have a question?
Yeah, I'm sorry.
I got two questions actually. In the case of the schools, you argued that schools should have, the lack of sprinklers in schools did constitute a distinct hazard. Another key word there is distinct, as opposed to just a hazard. How do you define when a hazard rises to the level of distinct hazard? As a fire official, we generally look at the fire records. How many schools burn, how badly fire is in the schools is foreseeable, but what kind of damage does it do? But if you take your thinking, your expert's thinking, then you got to look at all occupancies, not just schools.
Right.
And wherever the fire code says that a building should be sprinkled, like apartment buildings with 3 or more stories, then they all should be. And that's ridiculous. We can't get that done. So where in your view, with your experience, when does a hazard rise to the level of being a distinct hazard?
Okay, let me back up first because...
That's not the first one.
Okay, I'll get back to it. First of all, it wasn't our job to say this was a distinct fire hazard to safety, to life or safety. It was the school district's job to bring forth evidence that says a fire official determined that it was not a distinct hazard. You see the difference?
Is that what, I don't believe that's what you read from the code. It's when, in the opinion of the chief, it constitutes.
Okay, what it says is...
constitutes a distinct hazard, it does not constitute.
Okay, what it says is the code shall apply to existing conditions. So it will apply to an old building, except that conditions legally in existence at the adoption of the code. Okay, so this school was built in 70. In 1975, when the code was adopted, it was legally in existence without a sprinkler system. Okay, so it says except conditions legally in existence at the adoption of the code and not in strict compliance therewith, not complying with the code, no sprinkler system, shall be permitted to continue only if. So they have to meet that condition. Only if the chief determines that the condition does not constitute a distinct hazard to life or property.
But but I don't mean in this case necessarily, but in your experience with fire litigation, when does a hazard constitute? When is it distinct, or when is a hazard not distinct?
Well, I think the
that
way
adjective's in there for a reason.
Sure it is. And I think the reason that grandfather clause was adopted that way is to give significant discretion to the fire official. You can say anything is a hazard to life or safety or property. Okay. But it's got to be distinct. In other words, they're saying that fire official has to use his discretion to say, I think there is a real possibility that, you've got a chem lab in your high school, flammable liquids, you've got storage of containers in the boiler room that may be flammable. That's the discretionary part of it. The statute contemplates that the fire official is going to have to make that determination. Is it distinct? In other words, I think they use the word distinct in the sense meaning, is it reasonably likely to happen? Is it something that they want to...
That's what I'm looking for.
And you make a very good point, if you've got a hazard, anything can be a hazard to some extent, some possibility. And what the ramifications are economically and dollar-wise to all the buildings out there that have to retrofit a sprinkler system or whatever is enormous. It could be enormous. And that's, in fact, one of the rationales in the Alderman's case. The Supreme Court said, my God, these fire officials are going to be out there, they're going to have to inspect everything, they're going to have to write everything down. Otherwise, every building's going to have a sprinkler system, and the cost.
You guys couldn't handle all that.
I'm sure a lot of the contractors would love to start putting into one of those buildings. And it really was. One of the rationales was the burden on the building, on the fire official.
Thank you. And my other question was regarding the plumber shop. Now, if that fire official has gone through and not cited, if there had been some conditions that were not legally compliant at the time the fire code was adopted, and the fire official did not cite them as a distinct hazard, then is the fire official negligent?
No. There's no authority for it. Well, number one, he's probably got immunity, being a state official. In that case, I think it was actually a municipal official. But no, you can't use his oversight to say, okay, you're negligent, you should have cited him for it, and it wouldn't have been this damage. There's no authority for that.
You couldn't say to the owner of the building that the fire marshal should have cited this hazard because it was not legally compliant. The plumber is not responsible for that fire marshal's oversight, but then you're telling me neither is the fire marshal?
Well, it could have, I suppose, you could have a situation where the fire official testifies in a deposition, yeah, I dropped the ball, I should have cited it, but I didn't. But then that takes the alderman's case out the door, because the alderman says his silence impliedly means there's no hazard, there's no distinct hazard. You see what I mean? So, just by his silence. But now, if you've got deposition testimony, you can bet if I'm the plaintiff, I'm going to tell the judge, look, he wasn't silent on it because he found it wasn't a distinct hazard. Look at his deposition testimony. He simply screwed up. And that may very well affect the outcome.
I have about the same question. Could not that have inspector just plain missed it? No error of omission?
Absolutely. And there's a lot of inspectors out there who may have missed it and said, they can go one of two ways. They can be candid and say, I dropped the ball, or they can say, I didn't think it was a distinct hazard. And CYA, a lot of them may have that impulse to say, yeah, I saw it, but I chose not to cite it.
You're no doubt familiar with Craycraft, right?
Yes.
There, as a fire official, has the actual knowledge of the hazard. If he just missed it, didn't see it, he could have been careless. But if he didn't see it, he didn't cite it, he's not responsible.
Right.
It's almost better to miss something than to write about that.
And that was one of my arguments in the Bonomatic cases. I don't agree with the alderman's decision because by saying the silence of the building official is okay, that has a tendency to encourage oversight. And that risks not just property damage, but life. There were tenants. Well, there were tenants in this particular case in the adjacent buildings. But again, you recognize the fact that the building officials who are doing this kind of work have a pretty heavy workload as it is. Any other questions on, yeah?
How does that section worded now between adoptions of codes, like we're soon to be changing to the 94 fire code, are we then again in that cycle where the 94 fire code applies except when we make an inspection and the alternate case are silent?
The various versions of the code continue to use that existing conditions clause. So it's been uninterrupted since 1975 in Minnesota. So again, the code has been adopted. It was adopted in '75 and continues to be. They may update the versions, but it still goes back to the beginning. The key point in time is adoption of the code. For Minnesota, it's always 1975.
So then in many cases, when we change sections of codes, whatever had been inspected should probably be re-inspected just because the code has changed. I'm thinking more of outlying areas as opposed to in cities where it may not be a problem.
I don't know if re-inspection is necessary. Let's take the high school. If they had done one inspection, just one, and the fire official either didn't cite them for not having a sprinkler system or specifically wrote down, I do not consider it distinct hazard to life and property. That's all they would have needed. That's all they would have needed.
The inspection is in, say, 78, the code changes in 82 to require sprinkler systems, and now it's 95 to have a fire. The fire official has not made a decision, silently or proactively, that it's not a distinct hazard.
Right. If there's a change in the code requirements for when a sprinkler system is needed, based upon size of the openings of the building, distance between walls, yeah, I agree with you. If there is a situation like that, yeah, most building owners are going to be, it's going to be their best interest to have a re-inspection. Anything else before I move on? The second topic is that I want to touch on was the admissibility of tests or demonstrations at trial. In fire litigation, that's a very common tool that's used to explain to a jury exactly what usually the plaintiff uses it, but not always. It can be for the defense side too. But it's a way of explaining to the jury what they believe happened to cause this fire. And it's a lot easier to show them a videotape, to show them a demonstration, than to sit and have an expert talk in complex terms about, whatever the instrumentality might be. If you're talking about electrical arcing, if you're talking about spontaneous ignition, it's so much easier for a jury to fix themselves to a video and watch it. But typically, these involve a significant amount of time and money to prepare these. And as I indicated, it's very important for the expert who's doing that type of work to know ahead of time, before they even start doing the demonstration or experiment, what the judge's criteria is going to be for allowing the jury to see that. There's no point in having this nice videotape or whatever kind of experiment you want if it's not going to be seen by the jury. Now, there are cases where people do actual live experiments and demonstrations in trial, but most attorneys will tell you it's not recommended, it's too risky. You don't know what the result's going to be sometimes. You got a nice videotape where you've watched it 100 times and you go, yeah, we got it where we want it, now we'll show it to the jury. The current law on that is it's a test that the judge has to use. In order for it to be admissible, for the jury to see it, the test or demonstration must have been conducted under conditions and circumstances substantially similar to those existing at the time of the loss in question. It's what we call the substantial similarity test. If you don't have substantially similar circumstances, the judge is going to say, it's out. Now, let me give you some examples. In 1986, the Court of Appeals had an opportunity to deal with the substantial similarity test. There was a wrongful death action involving a motorcycle truck accident. A motorcyclist died. In that case, during trial, the defendant tried to use a motorcycle safety video. and the trial court let it in. On appeal, the Court of Appeals said that videotape should have been excluded because the video only showed accidents in which the motorcyclist was at fault. And all of the accidents that were on this videotape took place on highways. And the actual accident in that case occurred on a gravel road. So there you have an example, not real apropos for fire suppression, but an example of the substantial similarity requirement. In 1994, the 8th Circuit, the federal court, took a look at a similar case involving, this was a personal injury accident involving an automobile battery. And the plaintiff in that case sought to use a leak test performed on a car battery to show it to the jury. Well, the 8th Circuit Court of Appeals recognized the fact that the test in question, the leak test, was performed on the same type and make of battery as was in the car that caused the injury. And so the court said the purpose of that test is to show or to simulate what actually happened to cause the injury. Because of that fact, the court said you have to meet the substantial similarity test. So then the court said, okay, I'm going to apply the test, and the 8th Circuit said the plaintiff in this case significantly altered the operating conditions in the battery when the leak test was performed. Now, they didn't go into specifics about what operating conditions were altered, but it cited the fact that they were in the court's opinion, and as a result, they excluded the tape. And the rule to keep in mind there is, as an expert, if you're preparing a demonstration, the closer the experiment gets to simulating the accident, the more similar those conditions have to be to the accident conditions. So again, for demonstrations, you got to make sure what your goal is when you start. Is your goal to simulate what happened? And if it is, you better make sure you got substantially similar conditions, but you're not changing the operating conditions, etc. In this high school fire, the plaintiffs tried to simulate a coffee maker fire. And what they did is, instead of just showing this videotape with the coffee maker plugged in and started a fire, they tore it apart, they took out individual wires, stripped the insulation off the wires, they added copper oxide to it, they made a glow, electrical glow. Then they placed some of the plastic housing next to it, and eventually got a fire. The judge let it in. That's another issue. And again, our argument was that absolutely not substantially similar. Now, there's one exception. There's an exception to that rule. If the demonstration is simply to show a scientific principle, then you don't have to meet the substantial similarity test. Because it's not trying to convince the jury this is what happened in this case. It's just trying to say, okay, this is a scientific principle which forms the basis of our theory, so that test doesn't have to be met. Well, in the high school case, the plaintiffs argued, well, that's what we're trying to do. We're just trying to show a scientific principle of electrical arcing or glowing, and that they can start fires. The problem is their own expert testified before the videotape went on that he believed this videotape showed what happened on the night of the fire in the high school. So again, substantial similarities required. And again, we're waiting for the Court of Appeals decision on that. We're hoping again that they rule in our favor. On this topic, it's very short, but a couple of conclusions. Make sure that if you're in a case like that, clearly define your purposes and goals before you start doing the experiment or test or demonstration. If the simulation, if the purpose is to simulate the incident, make sure that you familiarize yourself with the operating conditions of the instrumentality so that you don't find yourself wasting a lot of time and money just to have a judge say it's not going to be seen by the jury. Any questions on that before I move on? Yeah.
Well, see the case of a building that is going to burn down. So it's kind of hard to produce a video showing how the fire came about in the building because the building's not there anymore. Now, the way computers have advanced so much, you can do a computer modeling of the building showing the fire and all that stuff. How much would they regard that as being substantially the same?
You have to apply the same test, but we actually considered that in the high school case. That is very costly, at least from what I've been told. But again, what you have to do is you have to find what scale you're using, find out if the computer program is specifically tailored to the type of construction. I mean, every little detail, down to what type of ceiling you had in there, were there fire breaks, when you're talking about path of travel of fire. Those types of things all have to be factored in. And quite honestly, it's going to be a judgment call by the judge. There's no guarantee that one judge is going to let it in and the other one will too. But yeah, you're going to have to factor in a lot of detail into those, into the computer graphics in order to make sure that someone's not just going to shoot it down by saying, well, you haven't taken into consideration ambient temperature, building construction, whatever. That's about the best I can tell you. There's no cases that have dealt specifically with admissibility of those, at least that have been published. Yeah.
How does testing something to a national standard such as UL or NFPA come into that? When you're testing to the standard is most likely not very similar to the condition that happened, except for a very small piece, maybe a fire rating or something of that nature. Could the testing of the standard be used as a similar condition, or would the contents of the room be applicable?
Generally, if you don't meet the standard, that will come into evidence readily, and that's very damaging. Because most of these standards are minimal standards. Automatic Corporation, for example, went well above minimal UL standards for including thermostatic controls in their coffee makers. And I think that, if I recall, the numbers are that a automatic coffee maker should have a runaway thermostat 1 in every 100 million because they went beyond UL standards. So the flip side of that is, can you get in evidence of meeting UL standards? Well, yeah, you can in a sense, but it doesn't do you a whole lot of good. And again, you're not really trying to simulate what happened here, unless you're talking about an incident where you're failing to meet those standards. And then you can bring in the basis behind the standards. Why was the standard enacted? Well, the risk of fire. Here's why. And if that is exactly what happened in this case, if that's your theory, yeah, then you can use it. Did I answer your question? Okay, the last topic I want to touch on is multi-party construction claims. Now, again, we're talking about a totally different area here. Multi-party, generally when you're talking about a construction lawsuit, you're going to have multiple parties. I'll tell you that right now, you probably all know. In the construction industry, you've got a lot of people with their hands in the pie. You've got the developer, the owner, the architect, engineer, the contractor, the subcontractors. And there's a number of reasons why you don't see a whole lot of cases where it's building owner versus the roofing subcontractor alone. From the plaintiff's perspective, I, as a plaintiff's attorney, look at a case like that, and I've had cases for condominium associations, townhome complexes, where I'm looking at the case and deciding who to sue. If there's no well-defined theory of liability, what caused it? Well, we think it might have been this, we think it might have been this. That depends on your experts. But if you don't have a well-defined theory, I mean, it's pretty obvious what the plaintiff's attorney is going to do is bring in everybody. Or bring in what I call the usual suspects. So That's one reason why you see plaintiff versus 3, 4, 5 defendants. The other reason is the plaintiff's attorney, frankly, wants the deep pocket. How do they know that the contractor they're suing isn't close to insolvency or bankruptcy? They want the insurance company who's defending the architect to be in there too. Now, attorneys are, of course, required by professional responsibility to at least have an articulable claim against these people before they start suing them. But that's not that hard. and if it is hard to find the expert, and there are experts who will find that theory. So again, you've got reasons for why you have multiple parties. And again, in certain cases, and I've had them, you've got problems not only with design, but with workmanship or with warranty issues. And those stretch to different parties. You've got the contractor on the workmanship, you've got a design problem, you bring in the architect. So those are other reasons. Now what about the defendant? Well, you've got cases sometimes where a plaintiff has a loss, but whether it be a water loss or a fire loss or whatever. And he's convinced, or the investigation determines, yeah, this was the result of the plumber who came in and used a torch. It was done 10 minutes before the fire was discovered. The point of origin was right where he was using the torch. Okay, well, in a lot of those cases, now the defense attorney's looking at it and saying, in construction cases, it's a little bit different. You've got, you want to pass the buck, okay? If my party's going to be in here, I'm going to see that all the usual suspects are in here to point the finger at them or to share the load. Distribute the blame. A lot of times it's just a knee-jerk reaction from a defense attorney. They want to bring in for what's called indemnity or contribution. Either you indemnify us 100% because we're not the negative party, or you at least contribute because you're partly at fault. So it's a little bit more, the defense attorney kind of feels a little bit better with the numbers on his side. So that's why that's just the basis for why multi-party litigation is very common in construction cases. Within that area, let's talk a little bit about liability of design professionals. Generally speaking now, the architect or the design professional is only responsible for the duties that they agree to under the contract. So you have to look first at the contract because that's what the court will do. That's the first place they're going to look in determining any issues of negligence, breach of warranty, breach of contract. What did the architect agree to do? What services did they agree to provide? Generally, the duties of the architect outside of the design, and the first question one's going to ask is, well, you're not just responsible, Mr. Architect, for designing this system. You're responsible for supervising the contractors who actually install it. You should have been out there on the project every day to make sure that it was put in the way your design showed. Again, the tendency in the contracts is to limit the duties of the architect or the engineer on supervisory type issues. What most of the contracts we're seeing now is that specific language says the architect's duties is to generally do spot or on-site inspections in a routine manner. But they're very careful to limit the language such that you can't construe it to be a promise that the architect or engineer will be out there to make sure that the contractors are putting this stuff in the way, specifically the way the plans say they will. Even if the plaintiff is not a party to the contract, a lot of times you've got buildings that have been sold 1, 2, 3, 4 times before a loss occurs. That plaintiff still, when you're looking at the liability of the architect, you still have to look to the contract, even though this particular plaintiff may not be a party to that contract. Now, the standard contracts, again, that we're seeing, require the detailed plans and specifications setting forth the requirements of the construction project. In addition to limiting the supervisory duties, a lot of these standard contracts are going to try and limit any exposure that the architect has. But the problem you're going to have is the actual knowledge, for example, of a defective installation. This isn't rocket science. I mean, it's pretty obvious. If there's evidence that the architect was aware of defective work at the time when a remedy is available, then they're exposing themselves to negligence, to liability. In those cases where there is a design problem, you have to look at proximate cause. Proximate cause just means the plaintiff has to establish that the design problem was directly related to the loss. If not, the contractor or the design professional is not going to be held liable. If the work was not performed by the contractor according to the plans and specifications, then you're okay. If you don't have, if the contractor comes in and prepares, or excuse me, does the work apart from or deviates from the plan, then you have no proximate cause. But you have a caution there. What the architect is going to have to show in those cases is that it was the deviation that caused the loss. If the architect approved the deviation, well, you're right back into it again. Okay? So in some situations you do have deviations by the contractors. That, generally speaking, is going to protect the architect if that's the cause of the loss. But you got to be careful. Some of those deviations work their way back into the knowledge of the architect or the design professional, and that's going to subject you to liability. Or at least the plaintiff is going to survive summary judgment by using that evidence and saying there's a fact issue for the jury whether this architect should have sniffed out this deviation or, having known about it, should have remedied it.
How does this work on design build? Where they put in a one-sentence design and install a fire sprinkler system in accordance with anybody's code. So whether you say involved in the stage or whatever. Or the contractor designs the system and installs it. Let's say we have a passive valve function where the head fuses, the water comes out when it's supposed to, when it's not at the rate of mount. You're telling me that Scott can walk away from that? His paycheck from the owner with no responsibility? Is the design, is the quote engineer?
Okay, what's your expert going to say? They need more information. What is the expert saying is the cause of the loss?
Let's see, with an adequate design, pipe size is choking down too much.
Okay, then you're going to. Then what I'm going to do as the plaintiff's attorney is I'm going to look at the engineer, the design professional, and say, you should have designed this in accordance with reasonable standards in the industry. Okay? And that doesn't necessarily mean that it just has to meet code, or it doesn't have to meet a public sector's okay. That's the minimum.
Does it have to meet his? When he puts out a performance spec that says design in accordance with a factory dimension, in terms of those, there are no plans. There's a one-sentence specification. You see there a lot.
Quite honestly, I would, whoever, the specifications, if they come from the manufacturer.
No, from an engineer.
Okay. Well, I'm going to have the engineer in, sure, but I'm also going to have,
The installing contract.
Yeah, you bet. The usual suspect. No, I may come in and say, Scott may have done 6 projects before this where he took more steps than what he took in this case. And that's going to be evidence of negligence. Or it can be. If it's a previous, if he's used previous design, which you didn't use in this case, and you got to start working your way backwards. Why did you use that design? What was the purpose of it? And if you may have an issue. One other area to keep in mind, correspondence. Attorneys love correspondence. And I can't tell you how many letters I've gotten and just looked at them and just started smiling. Oh, got it. I mean, letters between the contractors and the design professionals, arguing about which design is right, or whether you could, for some reason or another, you can't put it in the way it was originally planned. And be very careful. You got to do your job in the best way you can with using your education and experience, but be careful what you put in writing. If you disagree, if you're a contractor and you disagree with the design professional, that's fine. Make sure you're clear on what you're saying. I've had cases where the designer and the contractor are literally writing insults back and forth. And saying, you're crazy, you can't use that design up here in Minnesota. Oh, and I just sit there and love that. That's Exhibit 5, this is Exhibit 6. You're going to love this. And yet there's other letters where one of the parties says, well, yeah, the design isn't, the designer says, well, it's not what we drew up, but I understand your point, or it may work, or something, and they start to acquiesce. And then you've got a real problem. Then you've got an exhibit which may, show adoption of this design change. So make sure that in letters that go back and forth that you're very succinct and careful about what you say. Because you can come back and testify, no, what I meant by that letter was this, but the letter speaks for itself. And you can bet the attorney's going to say, well, if you meant that, why didn't you put it in the letter? Vagueness only lends itself to liability. That's generally the rule I give contractors and design professionals. You have to assume that those letters are going to get into the hands of an attorney. They're generally not, it's true, they're not generally subject to being protected under discovery rules. Anything that deals with the project, and it's going to be mountains of paperwork a lot of times, but the plaintiff's attorney will dig through them. And they'll find those letters. And again, they provide very strong evidentiary pieces to use for liability claims. So again, be comfortable with the contract language that you're entering into, particularly contract language that deals with duties and responsibilities and supervision of contractors. And choose your words carefully in correspondence. And if there's cases where you do have shop drawings, make sure that you make sure if you're going to be approving shop drawings, make sure that you do that carefully. You don't just rubber stamp them, because that can subject you to liability if there are deviations. And again, always keep in mind that unfortunately, as it may be, lawyers get bad raps because they're out, have a tendency to say, well, they're out there looking for lawsuits. But being one, my recommendation is be aware of it. Be aware of what the legal ramifications are, because it'll serve your best interest to make sure you're succinct in your letters, that you understand the contract. It takes more time, but just make sure that you're comfortable with what you're getting into. That's all I have. Thank you for your attentiveness. I know it's late, but I really do appreciate the opportunity to talk to you on behalf of my entire firm. We really appreciate it. If there's any other questions, let me know now or later. If you need my phone number, I can give you that. Thank you.
Very interesting. I'm sure we could have gone a lot of different directions with some of those too.